Okie dokie. Good morning, good afternoon, depending on what coast you're on. I am so excited to see those numbers climb and to have everybody with us today. This is such an exciting session. And I can tell that you're excited because we had a lot of signups for this one. So, just to remind you why you're here today, we are going to be covering how to court proof your practice guide for all of you out there working in mental health. We are excited to have Dr. Brittany Bate with us today. She knows this like the back of her hand, so she is an awesome resource. My name is Carrie Scott. I work at Spruce Health. Sometimes I forget to intro myself, and everybody's left wondering who the heck is this gal. But now that I have told you why we're here, very light housekeeping. And then I'll give you a quick overview of what Spruce is for those of you new to us. So just to let you know, this session is being recorded. So if for some reason you have to drop off or you miss something or you just want to revisit the content later, I will be sending a link to this recording later today, and you can watch it at any time. So no worries there. Also, if you have any questions while Brittany is presenting, please drop them into the Q&A feature at the bottom of your screen. The chat is disabled, but the Q&A is there for your questions. We are going to hold them for the end because Brittany has so much content she wants to cover. We're going to try to get through as much of it as we can in about 50 minutes, and then we'll have those questions for the last 10. She does have a contact slide at the end, so if we can't get to your question or if something, is pressing and you want to get to it later, you can also reach out to her. She's graciously offered that as a resource. Real fast, and then I'm going to pass the baton. So for those of you on this call who do not know what Spruce is, Spruce is medical communication software. It basically will transform your practice's workflows through a cloud-based solution. So it's nothing that you have to download or have on-prem. And it integrates your business phone with texting, faxing, telemedicine. It's all the bells and whistles. And it's really there to optimize your care collaboration. Streamline your client interactions, and even work with other providers in your office or folks that you need to connect with outside of your patients. So that's it in a nutshell. If you want to learn more, I encourage you to check out our website. I'm not going to wax on because we're here for Brittany today. And with that, I am going to retreat. I'm going to turn off my video, let Brittany intro herself, and get right into the meat of things so that you don't miss out on any of it. Brittany, thank you so much for joining us today. I am really excited you're here.
Yeah, absolutely. I'm so excited to be here. This is one of my favorite things to talk about. So, like Carrie said, my name is Dr. Brittany Bate. I am a licensed psychologist. My pronouns are she, her, and I am a group practice owner as well as a private practice coach. And I also did some trial consulting over my professional career. I was incredibly lucky to attend a graduate school that had a heavy emphasis in forensic psychology and assessment, but I recognize that most of us don't necessarily have exposure to this during our graduate programs or during our practicums. So I know this is a topic that brings a lot of questions and maybe fear, maybe anxiety. And I'm hoping to be able to put a little bit of that to rest for all of you today. My background, I completed my pre-doctoral internship at the Federal Correctional Complex in Butner, North Carolina as a forensic track intern. I primarily did forensic evaluations at the federal level, including capacity or competency to stand trial, dangerousness, both for risk of future violence and sexual violence, and other evaluations. Now I am a group practice owner. My practice is Be Bold Psychology and Consulting, and we are located in North Carolina. We provide sort of the full swing of services, but we do offer forensic, criminal, and court-ordered evaluations in addition to psychodiagnostic evaluations. I also am the owner of Bold Practice Builders, which offers trainings and systems to help and support clinicians in creating the values-aligned practice of their dreams. I hate meatloaf and grape soda, and I have 3 cats and a dog. So we do have a lot to cover today, and I am going to do my very best to really give us a bird's eye view of what is otherwise a 3-hour presentation. So we're not going to be able to dig into everything, but I am going to try to scratch the surface on the most important things, and ideally have you all walk away with some things that you can do right now to court-proof your practice, as well as what to do if you do get the dreaded subpoena. So hopefully, if I can accomplish those 2 goals, I'll feel really good about it. So This is sort of a general overview of what we're going to be going over. And like I said, it's going to be a bird's eye view and we'll be moving fast, but luckily there's a recording. A few quick disclaimers. This is not, professional, legal, financial, HR advice. But what it is a detailed training and sharing of information based on my professional experience, my own trainings and consultations with liability insurance, judges, attorneys, etc. What you should always do, and this is also a really important take home, regardless of any training, when court related stuff comes up, check in and consult with your liability insurance. That's what they're there for. That's what you pay them for. And most liability insurance companies offer free risk management consults. And if they don't, it might be worth considering checking out one that does, because they can be really, really helpful. You might also want to contact your own attorney or your local ethics committee or supervisor or a colleague. And I think it's just a general risk management strategy that's really important. You also want to make sure you understand your specific statutes in your state or jurisdiction and relating to your ethics code and your state licensure. So I'm going to be giving, sort of some general overviews, but it really does vary from state to state or jurisdiction to jurisdiction. And part of your homework after this is going to be to make sure that you understand what yours is for your particular state or situation or jurisdiction. And did I mention consult with your liability insurance? So, why do therapists go to court? There can be a lot of reasons, but I think one that comes up the most often, or one that I hear the most concern about, is usually related to custody or visitation in family court, or under the umbrella of child protective services. And those things might be related or might not be related. There's also the opportunity for criminal cases. And this might be evaluations, which could be specialized forensic assessments that if a person is trained and interested in doing, then they might end up testifying on that evaluation. There might also be court-ordered therapy as part of a deferment program, a plea, or sentencing. So maybe as part of the sentencing, a person was required to undergo 10 sessions of anger management or to engage in substance use counseling. It could also be for victims of defendants, where you might get involved. On the civil side of things, there's a lot where someone could end up needing or asking, or you might be pulled into potentially court-related work. So perhaps there's an accident, like a motor vehicle accident or an on-the-job accident, and there might be trauma, or we might be looking for a workers' comp type of claim or civil damages. In that way, they might ask for their therapist to, or they might want their therapist to come in and testify on treatment. There might be a malpractice case against someone else. There might be a dispute where someone's mental health or substance use diagnosis might come into play. There's also disability evaluations and guardianship, which both of those usually tend to be conducted as a separate type of eval by a specialized provider with that kind of training. But oftentimes, our clients don't necessarily know what they don't know. And so they might ask or see if there's involvement that could be had by their therapist as well. And it's important for us to be able to help them understand what our role is and what that would mean. So this is something I say, and this is sort of going to my first big take home that I want for everybody to have today. I truly believe that offense is the best defense. And that means from the very beginning, from screening referrals to preparing your paperwork, have your practice set up in a way that is going to protect you and ultimately allow for the best outcome for the clients that you do and do not see as well. This also means documenting carefully, competently, and conscientiously. So let's talk about screening referrals right from the very beginning. It's easier to keep the door closed from the outset. We do not have to accept every referral, and we do not have to help every person who reaches out to us. And I think it's important to remember that. We are helpers, and most of us got into this field to help. And also, it's important for us to think about and stay within our scope of practice. I think there's probably more than two reasons, but two reasons that I see the most often where people don't maybe effectively screen referrals or maybe take on a case that in retrospect or in hindsight, maybe they shouldn't have taken on. And I think part of it is we need referrals or we aren't full yet. And we think that we can help this person, we want to help this person, but sometimes that means accepting cases that we end up not necessarily being super happy that we accepted. And then again, we're helpers. I think that we want to do everything we can to help people, and people will reach out in distress and they really are seeking support. And it's really hard to tell someone no or to kind of put them in a different direction. A lot of times parents call and they are desperate to protect their children, and that makes perfect sense. But it can be really, really hard to tell a parent who is desperate to get their kiddo in, or they're desperate to come in, that we might not be the best fit for them or for what they're looking for. I think it's important to remember when we are setting our boundaries and screening referrals that there is potential for harm when we're acting outside of our scope of practice. There are so many wonderful, qualified, competent clinicians in this world, and there's someone that's going to be a good fit for that client if it's not you. So remembering that and remembering that you're actually doing them a service by not taking them if it's not going to be the best fit for you. Just a few things to think about or to keep a lookout for when you are screening referrals. So, if there's any involvement with the criminal justice system, that's sort of an indication that it's possible that there's going to be required court involvement on your part. And that might mean a treatment summary. It might mean getting on the phone with a probation or parole officer. It might mean testimony. Same thing with DSS involvement of any kind, including previous DSS involvement. It's possible that your notes or your session information might be required or requested at some point. If there is current or upcoming divorce proceedings, that is, of course, not always the case, but they can sometimes turn into higher conflict, or even in non-higher conflict, there can be questions or requests of a therapist to come in and to say things or to share notes. If there's a custody agreement in place, but it is frequently debated or changed, is another thing to think about or look out for. An acrimonious relationship between separated parents, recent changes in the extended family. Either parent says that they have an attorney on standby. We have gotten that several times at our practice, or we've actually gotten folks reaching out and CCing their attorney on the initial reach out. Or if there's an accident of some sort, visitation, anything, any mention of any of this kind of stuff, custody, visitation, accident, trauma, malpractice claim. So I wanted to give you a little script because referring out can be hard. And this is just an example that you can, of course, tailor to the needs of your client. But this could be an example of what you say if someone reaches out and they're not the best fit right from the beginning before you even take them on. And here's another example. This is more specific to court-mandated treatment or custody and visitation. I am going to provide Carrie with the slides, and they will be provided to you after this. So I'm not going to, read everything on every slide, but I do want you to have the information, which is why it's on the slide. So talking about scope of practice, it is so important to stay in your lane. So things that you are, and you might be more than these things, but generally speaking, if we're thinking about a licensed mental health professional, we are trained to assess, diagnose, and treat mental health conditions. We are bound by HIPAA and confidentiality. We are bound by our professional code of ethics, and we're bound by our scope of practice. So our education, our training, and our experience. Unless you're hired for this specific purpose, you are not any of these things. You are not a custody evaluator. You are not a parental capacity evaluator. You are not a parenting coordinator. You're not a forensic interviewer. You're surely not a fortune teller or any other type of expert outside of your scope of practice, and reminding what our scope of practice is. This is a really good sort of rule of thumb and starting place for you when you are thinking about if you can do this thing or not. What did your informed consent say that you can do and that you will do for this client? That's all you can do. So let's think about that informed consent. What is and what is not your scope of practice? And do you have a statement about your scope of practice and your informed consent? At our practice, we do have kind of in there what we do and what we don't do. It's a little bit different for our practice because we do have psychologists who do offer forensic and court-ordered evaluation services, but in the realm of therapy, we make it very clear that our scope of practice is to assess, diagnose, and treat mental health conditions, and that we are not able to offer any information regarding custody, parental capacity, or anything of that nature. What's your role with this client? So thinking about that, is it therapy or is it evaluation? And what kind of an evaluation? What's your policy with minor children? And I'm going to talk a little bit about some things to consider, but this is another space where you're really going to have to make sure that you're doing what's right for your own jurisdiction, and your own practice in this regard. But thinking about, issues of consent or assent, thinking about an age of consent or assent, and thinking about custody related items. That might mean consent, communication with parents or guardians, and a variety of other things. So, some things to think about for your policies for those of you who work with minors. State laws are always our starting point, followed, by our ethics code and our professional organization's best practice guidance. For us at our practice, we are in North Carolina. We require any parent with legal custody to complete paperwork. So if they have legal custody, which is different than physical custody or can be different than physical custody, we require them to complete our informed consent paperwork. We offer an intake option to any parent with legal custody, and that can be done with the other parent or guardian. That can be done separate. It's up to them, but we do offer it because we believe that that is, generally speaking, best practice and leads to better outcomes down the way. If a parent says that they have sole or full legal custody, we require the most recent court order or custody agreement on file before beginning with the child. And we require a notification to the other parent or guardian that we're meeting with the minor client unless there are significantly extenuating circumstances. And generally, if there are these significantly extenuating circumstances, we usually refer out as it's probably not the best fit for our specific practice. We have a policy as well that is in our informed consent about communication about the child client. Generally speaking, that policy is that we don't engage in one-way or unilateral communication with one parent. We ask that parents do CC the other on any email communication. And if there is ever any clinical check-ins, we offer for both parents to be involved or for us to do a summary through the portal of what was discussed. But it's very, very easy and a slippery slope to get pulled into triangulation between two different parents. And it can ultimately impact, if you do have to engage in any kind of testimony, it can really impact testimony, and it can also impact the look of the care that you're giving to the minor client. This is one of the most common things that I see as being problematic. Do you have a policy on revoking consent? And ideally, is that aligned with, your state or jurisdiction? And do you have a policy on how you want to approach that? At our practice, we have a policy in there, but we do ask if anyone wants to revoke consent that we get at least one or two sessions to close out with the kiddo. And if it ever does happen, we typically try to have a conversation with that parent about what their concerns are and see if there's a way for us to mitigate that. We also have a mandatory disclosure of treatment information section, and this was actually pulled from my own liability insurance's library of resources. And it just talks about, here's some things that we have to disclose, that we have to break confidentiality to disclose to parents, and here's some examples. And here's some examples of things that we might not. It gives the parents an opportunity to ask questions and to clarify, and the kiddos get the same conversation so that they have an understanding. I feel really strongly that informed consent has to be informed. So if we are not informing people of their rights, then they cannot make an informed decision about what they choose to share with us or not. And it's ultimately up to them what they choose to share with us, knowing what we then have to potentially do with that information. We also include in our informed consent both parents to initial an agreement essentially to not request records, especially for court use. Now, that doesn't mean that they aren't allowed to, because by law, they are allowed to. What it means is it gives us an opportunity to have a conversation about that ahead of time, explain our reasoning as to why it's really important, both currently and for the long-term, mental health and relationship with therapy for your child, that you agree not to request or utilize their therapy records in any court proceedings. And then if they do end up requesting it, it gives us an opportunity to go back and be like, hey, remember this thing in our informed consent? Do you remember what we talked about with that? And have another conversation and see if there's a way for us to be able to, again, mitigate that request in another way that's going to be more protective of the minor's records and of the therapeutic alliance. And I do have examples of this in the course and in my Etsy shop. It's also really important to have a fee schedule. So have it in your informed consent ahead of time. When I'm in therapist groups and I see people talking about getting a subpoena, one of the big questions that comes up is, can I charge for this? Generally speaking, yes, and you should charge for your time on your calendar. But it gets a little trickier if you haven't already had the information in the informed consent, if we're trying to do a fee agreement later, which isn't impossible. It just is an extra step and maybe is a little trickier. So my suggestion is to have your fees in it ahead of time. And remember that providing testimony is a lot more than just showing up on the day of court and talking to a judge. There's a lot of prep work that happens behind the scenes, and I want you to think about that when you're thinking about your fee schedule. So that might be seeking outside consultation for yourself, whether it's other experts or an attorney or your liability insurance. It's going to be reviewing those records in detail so that you can recall dates and statements. It might be creating treatment recommendations or creating a treatment summary to have instead so that you don't necessarily have to go in and testify or provide a whole record, but you should get paid for that time. It might be prepping some educational materials about diagnosis or interventions and prepping them in a way that's easy for the trier of fact to understand, which I will talk about a little bit later. And then practicing your testimony and consultation with the attorney. If this is relevant, if you're doing an evaluation, you also want to review test manuals and talk about norming samples and be able to just make sure that you can talk eloquently and confidently and competently about the materials that you chose and why you did or didn't use them, and for the diagnoses or the opinions that you come to. So, some things for you to think about as we're digesting a lot of information here. What is your hourly for court involved or court related work? It does need to be reasonable and customary. And I know that that can be really subjective, but what I sometimes see clinicians do is setting $1,000 an hour for testimony or any court-related stuff. And what I've seen judges do is say that they don't have to be paid for that time and that the person who hired them actually doesn't have to pay them because that is not reasonable and customary. So setting a really, really unreasonable and non-customary fee for anything court related is not a good strategy to get you out of court. There's better strategies to potentially help you to be able to avoid court if it's something you really don't want to do. Do you require a retainer if you're being asked to clear your calendar from paying clients on this date for a deposition or to be in court? And how much is that? How many hours is that going to be? What does that include? Does it include a certain number of hours of prep work? Does it include travel? Does it include time waiting to be called? And when is that deposit or retainer due? And when is the full amount due? So do you do a deposit of 50% and then the full amount is due 3 days before you're scheduled to testify? Or do you try to collect it after? That would not be my recommendation, but some people have to do that because of state law, or they just feel that that is best practice. And then what if there is a reschedule? What's your policy with reschedules or cancellations? And this may need to be guided by, again, state law. And it's important to ask your liability insurance and your own practice attorney, but it's something to think about because if you've cleared your whole calendar and it gets canceled the day of, that is not the most favorite thing that ever happens. So if existing clients become court involved, I think the script looks a little bit different here because you want to be careful about your choice to make recommendations or not. So the example that I like to give is you have an existing client and a custody dispute comes up. And let's say you're seeing one of the parents. Do you want to give that parent a recommendation for a trusted custody evaluator in your jurisdiction or not? I think there's pros and cons to both, and I will leave that decision up to you. But there could be opportunities to have them talk with someone else, have them talk with their attorney to get those resources. It's also important for you to remind them your role. So I am acting as your child's therapist, and my only role is to provide mental health treatment to your child. I could come in and testify, but it's probably not going to be very helpful because all I'm going to be able to speak about is anxiety. I will not make any conversation or any recommendations relating to custody, adjustment, parenting, or anything like that. So just reminding your current clients of what your role is if court involvement comes up. And here's some of the scripting about it. All right, we are jumping into Subpoenas 101, what maybe many of you came up to hear more about, and the most commonly asked question I find when it comes to court-related stuff. So, what are subpoenas, first and foremost? They can be for your records. That's a subpoenas duces tecum. I don't know for sure that I pronounced that right. I find that I pronounce things in my head, and then I realize that they're pronounced differently when I actually hear them said out loud, but that is what I say. Or it could be for your appearance or somewhere, like show up on the courtroom steps with the whole file on this date, on this time, or for your testimony or deposition. Subpoenas can be issued by your client's attorney, another attorney, or a judge, sometimes through the clerk of court. And there's going to be different processes depending on who is issuing that subpoena. And they can be delivered by a sheriff or a deputy or a process server. And they can be delivered by hand, by mail, by telephone, or by email, ideally certified mail. Again, you want to check with your own jurisdiction, but generally speaking, a subpoena is not considered to be valid if it's not delivered by hand or by certified mail. I have gotten subpoenas by email and I still reply to them, but if it is not delivered in the way that it is like legally necessary to be, it makes your grounds for objection far, far easier and the process far easier. Not that the process is necessarily hard otherwise, but that is just sort of an automatic. This was not given the correct way, please hang up and try again. Something to think about, and this is just some more homework for you all. How is your practice going to handle receiving the subpoena? Technically, but for those of you who might have employees and also unhelpful for your clients, you don't have to accept it on behalf of your employees or contractors. You don't have to provide them, and you don't have to provide the process server with contact information either for your employees. It's not really that helpful. It's just probably going to delay the inevitable. So I I wouldn't necessarily advise that. These are just some things to consider, and I'm not going to go into too much detail about these kinds of things for the purposes of this presentation, but just thinking about this, what about telehealth? If you have a telehealth practice or telehealth clinicians, do you have a scripting or process for your staff to receive the subpoena? And who is the point person that handles all the subpoena related issues, if there are any? This is an example of a subpoena for the state of North Carolina, and it just has a little bit of information about what each section means. So you can see, the plaintiff versus the defendant, and then you can see what you're commanded to do. I'm looking over at my bigger screen, so if you see me looking over there, my eyes can't quite see the small screen. Um, is it to produce items? Is it to appear and testify? Is it in court or a deposition? And then underneath, there's instructions on following the subpoena or the list of things to produce. So typically in that big section, it talks about what exactly it is that you need to have. The next section down talks about the where and the when to appear or produce the items. And then it talks about who is the person or entity that issued the subpoena. This part is really, really important to pay attention to. If it is an attorney, there might be different steps to take. And again, I know I sound like a broken record, but I just want you to hear this very clearly. It is jurisdiction dependent, but it could potentially be issued by the clerk of the court or the judge. And if it is essentially a court order, which means there's a different process entirely. And it is as good of a court order, which means you have to comply for the most part. So we're going to go through step by step. What do you do? Little decision tree vibe if you get a subpoena. So the first thing that you're going to do is breathe. You are not going to respond immediately. You're going to give your nervous system a second. You don't have to panic until you have all of the info. So breathe, take a beat, and start remembering that you attended this training. Remember that you have slides that tell you what to do, and follow through once you're ready to do so and you're feeling a little bit more regulated. Remember, you're not required to speak to anyone's attorney if you're not comfortable doing so. You can have someone do that on your behalf, and you're going to stay in your lane. So the first thing that you're going to want to do is you're going to want to look at that subpoena and see, is it attorney issued? or is it through the clerk of the court or judge issued or court ordered? And that is going to be kind of the first step. You're going to contact your professional liability insurance and you're going to inform them of the subpoena and you're going to request a consult with their attorney or with a risk management consultant to review your options and make sure that you are on the right track. I do this every time I get a subpoena. I have received a lot of subpoenas at this time. I feel very comfortable, obviously, talking about it. And it's still best practice to talk with my professional liability insurance every time to just make sure there's nothing I'm not thinking about because it's stressful every time, too. The next thing that you're going to want to do is contact the client that it's related to directly to notify them of the subpoena and see, do they even know that this has happened? What is the purpose of this from their perspective? And then this is an opportunity again to review your scope of practice, your court-related fees, a treatment summary option to decide if it is an attorney, not the court ordered, if it's an attorney issued subpoena, do they want to sign a release of information for you to talk with the attorney to get more information? And it can be a limited release of information. Or do they want you to comply with the subpoena? It might be that their attorney sent it to you. They already have discussed with their attorney what they want, and they were just waiting for you to call to talk with them a little bit more. But this is also an opportunity for you to then make sure they fully understand the risks and benefits of you releasing their record to their attorney to be utilized in court and to talk with them about those options. Attorneys don't always know what that really means. They don't always know what is in our records, and they can sometimes give pretty bad advice. So it's important for us to be able to chat with them a little bit more about what this means if you do release it. If it's not from their attorney, or if they don't want you to release it, then we can talk about that in a second. But there might be an opportunity for them to sign a limited release of information so that you can ask the attorney questions and try to get a better understanding of what they're really wanting. So if they say yes, contact the attorney and ask some questions to better understand their request or need. It's really, really important that you don't get adversarial, that you don't get into an argument with the attorney, and that you don't give client information that you're not allowed to. What that limited ROI would look like would essentially be acknowledging that this person was a client, that you received the subpoena, and that you just want to better understand what they're looking for or what they believe that you can provide them for the case. And it's just getting information. If they ask you a question and you're not sure if you can answer it or you're not sure how to answer it, just say, I'll get back to you on that, or let me think about that and I might circle back, something like that. And then you can decide. You can take a beat, you can talk to your professional liability insurance, or you can call your own attorney and see if they can handle it on your behalf, because that is also an okay option. So we already kind of talked about these pieces. So if the client says no, no, I don't want you to release my record to my ex's attorney to be used in this custody dispute. You can have your liability insurance usually handle it from there, or you can have an attorney handle it from there. And depending on your state, there's going to be different things that you likely have to do. What I want you to, under no circumstances, do, unless you are absolutely without a doubt allowed to in your jurisdiction, do not ignore the subpoena. I see this, the number one thing, the number one piece of advice that I see in therapist Facebook groups or listservs or Discord servers is people saying, oh, it's from an attorney, just ignore it. Do not ignore it. Please do not ignore it unless your attorney gives you the advice to ignore it. I was involved in a case in North Carolina where an attorney issued me a subpoena. I went through all the steps that we're talking about here, and I responded and cited privilege as my grounds of why I will not be complying with the subpoena. I replied, but I won't be complying. And I never heard from them again. What I did hear, though, was that another clinician was also subpoenaed and they chose to ignore it. And when the attorneys took my objection and the non-response from the other person to the judge to get a court order for me to do the thing that they want me to do, which the judge didn't do, the judge actually did hold the other clinician in contempt for not replying. It's not for not complying, it's for not replying. So again, it really depends on your state. I want to name that very clearly, but please, please, please don't just choose to ignore and please don't just believe what a colleague says in a Facebook group. So after you talk with the client and the attorney and you figure out kind of what they're hoping to get from you, you can determine your next steps. So this is if you did talk to the attorney. We already talked about this piece. So if they consent to your compliance with an attorney issued subpoena, these are some things that you can choose to do. If the client does not consent, again, your liability insurance can handle it, but you have to have some sort of motion to object on the grounds of privileged communication. In North Carolina, it's a newer-ish rule. You also have to file, you yourself have to file or have an attorney do for you a motion to quash. So it is important to have an attorney that you know that can be in your corner or through your liability insurance that can do that for you. So if you reply and object, and the attorney can then petition the court to order your compliance. If they succeed, then you're court ordered to comply. Get back on the phone with your liability insurance, invoice for your services in accordance with your fee agreement, and go through the preparation process, giving only what is required and only to who it is ordered and where it is ordered. There is some nuances that I just want to name. I was required to provide a full file and to like show up on the Charlotte court staircase at 9 a.m. on a Friday. And I live like 2.5 hours from Charlotte. So usually you can find information for the judge's clerk. And so I reached out to the judge's clerk and I asked if it would be okay to do a either certified mail or a digital file in lieu of me standing on the steps and being like, hi, can someone take this? And they said that was fine. So usually they can be very, very reasonable if you just ask the question. So don't be afraid to ask for something or ask if there is another way or a different way. It also might mean asking for an extension, or it might mean, hey, I'm actually not going to be in the country on July 7th, so I'm not going to be able to testify. What are our other options here? A lot of people will get in sort of a bit of an anxiety or a freeze space that leads them to then not replying or not complying because we're worried that we have to do this thing or else we're going to be immediately jailed. And that is not the case, but we do have to have a conversation. And usually people are pretty understanding that we are humans that have lives and plans and that we can't typically drop everything to, return to, the US or the state or whatever by July 7th and show up to do this thing. Then if you have to testify, prepare for that. So just a few things to remember. You're not required to talk to attorneys. We have very different roles and jobs than attorneys. They do not always understand HIPAA and what our specific roles allow for us to even talk to. They might think we can come in and say something very different than what we can ethically do. And they're accustomed to adversarial work. They're used to pushing boundaries, and their entire job is to win their case for their client. So do your best to not take it personally. And again, not every single attorney is going to be adversarial or challenging by any means, but some will, and just do your best to kind of detach from that. They are doing their job the same way that you're doing yours. And I imagine that everyone on here has had some experience handling difficult people and do it the same way. Do it compassionately, do it with curiosity, and do it with firm boundaries. Some things to think about with documentation that I want you to sort of walk away with. This is the guiding rule for my entire practice all the time. Document everything as if these notes could be read aloud in court in front of your client, because they just may be one day. Ideally, I would suggest documenting the least information necessary for ethical, legal, and insurance compliance. Nothing more, nothing less. And document objectively. Do your best to name objective information as opposed to subjective or personal opinions. I get a question a lot about psychotherapy notes. I've done several trainings on these, both with judges, attorneys, and my liability insurance, and they can be fair game. There's a whole spiel I could go into about this, and for the sake of time, I won't. But just know that psychotherapy notes can be fair game, and especially if there's even a scooch or a smidge of anything that could be reasonably considered clinical or clinically relevant in there, the entire psychotherapy note then becomes a progress note. It is not a psychotherapy note. I will leave that there just for the purposes of this. Thinking about, what if releasing records could be harmful? Then what do we do and what's our process there? And just really, really important to note, you cannot release third-party records. So if I did a psychological evaluation and I shared it with the client's therapist, and then the therapist is court ordered to release the file, they cannot release my evaluation with that file. That is a third-party record. The court needs to order me to release the evaluation separately. Oftentimes we can offer a treatment summary, and that ends up being more helpful and ends up protecting more information for our clients. And so that's something to just think about. Remembering your scope of practice and staying within that for the treatment summary. Formal language is typically required with an easy to follow layout being helpful for the trier of fact. Keep it short and sweet and just stick to the basics of what is being asked and provide that information. Provide dates and exact quotes when possible and relevant, but don't overquote. And remembering that, the human memory is fallible. So it's not a place for personal observations, and it's definitely not a place for opinions, especially opinions relating to whatever the ultimate question or ultimate issue is, unless that is your job. So what I mean by that is, unless you did a custody evaluation, it is not a place to talk about custody. Making recommendations regarding mental health treatment only if your role was as a therapist, and leave the rest open for the attorneys and the judge to interpret. I want to talk a little bit about witnesses and witness types. Um, the broad overview of this is just that there are, generally speaking, three different ways that one might be involved in court or could be utilized in court. The first might be as a fact witness, and this might be, although sometimes these people are also considered expert witnesses. It depends on the judge and the jurisdiction. But generally speaking, this might be someone who's engaged in a professional psychological relationship outside of or unrelated to the court or forensic circumstances. So maybe they did therapy, or maybe they provided a separate clinical assessment to inform, something else. Generally speaking, our role as therapists is to get the clinical needs met. Typically, we are coming from a space of healing and mental wellness and aligning with our client. And so the goal is typically the best clinical outcome from our client in that role and in that space. It's a little bit different from an evaluative expert who is hired to assist the trier of fact in answering the ultimate question. So that might be, is this person capable to proceed to trial? Does this person have appropriate parental capacity? Should the custody situation be here? And for that, the goal of the clinician is to be objective, sometimes challenging and more skeptical, to consider multiple data points, and to provide as much as we can and as clearly as possible the trier of fact with the information that they want to use to make their decision. We are typically indifferent to the outcome. We should be indifferent to the outcome. Our job is to just go up there and do a good evaluation and do our job. The other way might be as a consultant. So this usually involves no evaluation or contact with any person, with the plaintiff or the defendant. Usually, this is just us coming in and offering consultation services. So maybe I'm reviewing a report that was submitted and I'm helping the attorney to kind of look at some of the gaps in the report. Or maybe I'm helping the attorney to develop their cross-examination questions. Or maybe I am taking the stand as an expert on PTSD and helping the judge or the jury understand really what PTSD can look like, or what grief can look like 3 years later, or something like that. So remember what kind of witness that you are. Therapists that are offering treatment should technically be a fact witness, but they oftentimes are sworn in as an expert witness. It is judge dependent. Essentially, we've heard things, we've observed things, we've saw things, and beyond describing our diagnosis, our prognosis, etc., we're typically not there to give an opinion. Opinions are usually sought by an evaluative expert to assess and answer. Give you some examples. What we can do. This person came in on a certain day, they said certain things, and this is how they appeared. What we can do. We diagnosed Ms. Jones with anxiety disorder. What we cannot do and answer. Does this person's mental health diagnosis impact their ability to parent their child? That's a parental capacity evaluation. We cannot comment on that. Do you have an opinion on if this person should have custody? I mean, I have an opinion, probably. Like me as a human and even as a professional, particularly one who's done custody evaluations, probably does have an opinion, but no, that is not my role here, so I'm surely not going to give it. And instead, what I would say is I did not perform a custody evaluation, and thus I don't have a professional opinion. Clarifying with the attorney ahead of time what you can and can't speak to can be really helpful, and it can lower the anxiety and lead to just a better experience overall for everyone. So, is this a normal reaction a child may have if they've been sexually abused? That might be something that you can answer. Maybe you can offer psychoeducation onto how a child who has been sexually abused may behave or what might be some things to look out for. But do you think this child has been sexually abused? Is a specific evaluation that is done by a specific kind of evaluator, and that question you should not answer if you're acting as a therapist. If they decide they don't want you to testify after having a conversation about what you can and can't do, they can withdraw the subpoena, but you do need it in writing. I'm going to very briefly just go over some qualities. And again, this could be a whole hour in itself, so I'm just going to give you the high points here. But there's four evidence-based principles of effective testimony, and it has to do with credibility, clarity, clinical knowledge, and certainty. Credibility is further broken down in these ways. These are the factors that were analyzed in coming up with these domains of knowledgeable, trustworthy, confident, and likable. So, taking a second and just looking at those factors and thinking about them. Warmth was also actually found to play maybe even a more important role in person perception than competence by jurors. High warmth people use we when discussing members of the scientific community. They use personal references, so they name the plaintiff or the defendant, Mrs. Jones, as opposed to saying the defendant, and typically engaged in moderate levels of smiling. Clarity kind of gets broken down that for the most part, experts who communicate in clear, comprehensible, and non-technical manner are more persuasive than those using complex terms and jargon. So instead of saying euthymic, say stable mood. Instead of saying flat affect when describing someone, say, showing limited or no facial expressions. Thinking about how to talk about information in a way that a layperson will understand and relate to. Then, in terms of clinical knowledge, judges and jurors prefer expert witnesses who focus on clinical as opposed to scientific issues in their testimony. Certainty is important as well. Jurors in one study identified a willingness to draw firm conclusion as one of the most important expert witness characteristics, second only to the ability to explain technical information. Big caveat though, jurors do like experts who are willing to make reasonable concessions. Sticking to your guns and or totally refusing to acknowledge the potential truth of something leads to perceptions of low warmth and low credibility. So, Dr. Bate, is it true that Mrs. Jones missed 17 out of 32 therapy sessions? Yeah, I mean, if it's true, it's true. Yes, that's true. That would be an example where, if it's true, it's true. It might not look the best for Mrs. Jones, but it's true. And so wanting to give those reasonable concessions. Dr. Bate, is it possible that, and you can ask something else that's possible. I usually suggest saying it's possible, anything is possible, but it's not probable if I really feel strongly that that is not the case. Just some general tips to increase overall credibility that I have here as a summary for you all. Take your time, breathe, take a sip of water, take some time before replying, speaking clearly, limiting answers to the questions that are asked, being comfortable with answering no and I don't know when appropriate. It's really, really, really important when it's appropriate. And then using a logical and professional tone and the same tone for direct and cross-examination. Do not be more defensive when you're getting cross-examined. When sharing info, turning slightly towards the judge or the jury and talking towards them tends to be viewed as higher likableness, especially when you're reaching the most important points of your testimony. Having a fidget or a sensory item can be really helpful. I've got like my favorite little one right here that I've just been kind of fidgeting with over here, but you can have it in your lap or on your water bottle. And then a note on humor. Don't do it. Do not use humor. I know a lot of us maybe use humor to lighten, nervous situations, but do not do it. We are wrapping up here quite soon. So preparing for success, review your notes, learn how to talk about jargon in a way that is digestible to a layperson, meet with the attorney, If you can, meet with a supervisor to talk a little bit more about your testimony and bring the relevant case material with you. But if you bring it on the stand, it's fair game. So be cautious about what you do bring. Don't bring anything, let me go back. Don't bring anything that they don't already have access to because then it can be admitted into evidence. And then, pre-trial trip could be really helpful if it's an option for you and have something to do while you're waiting and consider mindfulness, grounding, and breathing exercises. I'll leave this here. Like I said, you're going to get your slides, but this is just some homework for you to consider and things that you can implement right away. Like I mentioned, I do have a course. It's a 3-hour on-demand course. You can absolutely take a look at it. I have it linked on the slides. I also have informed consents or fee agreements in my Etsy shop. The information is there. We do have a code for you to use for 10% off of all of those things. And I also offer one-to-one paid consultations. Just shoot me an email, and I am happy to answer some questions now.
Oh my goodness. That was so much incredible information, Brittany. Like, holy moly. Okay, we have a ton of questions. I'm going to just jump into some of them. If we cannot get through them all, I will send these over to you after we wrap. And, maybe you can kind of go through and decide that you want to answer some of them and send them out to the group as a whole later on. Um,
Absolutely.
okay, so, oh God, there's a lot of these. All right, I'm going to start with some. So, if we want to do family therapy, but we don't want to weigh in on custody matters in court, how do we specify this in our intake interview and paperwork?
I think that's part of that scope of practice. So if you're doing family therapy, your goal is to offer family therapy. Your goal is to meet the goals of the family system, and that is what your role is there. And you can't weigh in on custody. A custody evaluation is a specific evaluation that a person with specific training has to do. And so I think it goes back to having that very clear in your scope of practice.
Okay, thank you. For screening, is current or upcoming divorce proceedings related to all clients or just when working with children?
It's really your preference. And again, like that's not an all of a sudden, red flag that you might have to be brought into court or anything like that. But it can be, the individual client, the adult client might think that or want you involved in court, or when working with children. It could truly be either. And so it's just important for you to think about if that is something that you want to do. And if so, what do you have in place to protect you?
Okay, great. If we are subpoenaed by a parent in a custody case, can we charge that parent for the hours that it takes us to travel and attend court as long as it says in our rate in the rate sheet?
Generally speaking, yes. There are a few states that have some limits on that, and I would obviously advise you to talk with your liability insurance. But the way that I think about it is you're not being paid for testimony. You're being paid to have that time reserved on your calendar as a professional service, and that is ultimately what's happening. You're probably canceling paid clients to be able to do that. And yes, if it's in your rate agreement, generally speaking, you can. We do.
Okay, that's great. If you would like to be able to do custody evaluations, but it wasn't part of your training, how do you gain competency in that?
There's some good trainings that I think there's a couple through probably through like concept trainings, but it might be worth it to look into the American Academy of Forensic Psychology, AAFP. They have virtual trainings, I think on a quarterly basis, and they also have in-person ones once a year. They're wonderful, and there's usually some stuff around custody. After that, I would absolutely recommend making sure you do your first one or two under paid supervision just to make sure that you can talk through the nuances because custody matters are the ones that have the highest rates of a malpractice suit coming against you. And so you want to make sure that you're really well protected in that.
Okay. In families with two parents who are bio parents and married, would it be good practice to have both parents sign informed consent, or is one parent sufficient in most states?
We have one parent do it. If they're married, we just have the one and that's fine. But if you want it to be your best practice, you can have both people do it if you'd like.
Okay. And does your practice notify the other parent that you are meeting with a child? If so, how do you notify them?
In both our informed consent, in our confirmation email, and in our background form for the child, we actually ask for the information and we say that we're going to notify, but ideally ask them to give the other parent a heads up so that we're not essentially cold calling. Again, there's some nuances there for sure. When we're talking about like domestic violence protective orders or things like that, there surely is nuance to that, but that might also just be a case that we're not able to take at that time, or it doesn't feel like the best fit for us. So it's just about making sure everyone's on the same page, and our admin will notify, but we ask ideally that the parent CC them on an email to us.
Who typically pays the retainer or fees when you go to court?
So what we have written is that the person who requests for our presence to be there is going to pay the fee or the retainer. However, we do put it in our fee agreement. This was a lesson learned on my part, that if for whatever reason the other party refuses to pay, the identified client is responsible. I recognize that sounds harsh, and I do recognize there is the potential for financial abuse to be utilized here. However, they can typically get reimbursed for those costs through their attorney. Their attorneys can hash it out. If the client that is ours pays us, they can typically hash out from their attorney that they pay them back and reimburse them.
Okay. And do you typically get paid upfront to ensure payment?
We do, yes.
Okay. Do you recommend meeting with a lawyer to set up client paperwork? And if so, what kind of lawyer would that be and how do you find them?
Yeah, I think it's always really helpful to have an attorney review all of your paperwork. I've had attorneys review all of mine, and ideally an attorney in your state. I think that asking colleagues what attorneys they've used to help them with their private practice paperwork setup, and asking just around, and potentially asking forensic psychologists in your area too, as their attorneys might be able to offer a little bit more information about fee setting and informed consent and stuff like that.
Okay. And if this is a practice that's just starting out or they don't have a ton of cash, are there some affordable options for people? Like, is there a low budge path here?
For what? For like
Paying a lawyer to review.
Um, I mean, it's possible that a good option could be also checking with like your state association if you're a member of that. They might have some templates. Your liability insurance might have some templates. I have templates that are attorney approved. They are for North Carolina, so that is a caveat, but there's also an opportunity to buy a template and then have an attorney review that template as opposed to having them create it on their own, and that might end up being a little bit more affordable.
Okay. I know people have different philosophies for note taking. Some people write as little as possible in their notes, thinking that this will protect them and their clients. Others operate under the rule if it wasn't written, it didn't happen, and they record as much as possible. What's your philosophy? And I know you sort of touched on this, like to document everything. Yeah.
I would say I tend to document as little as possible, but I think for things that are going to be, I think my caveat there is when it comes to risk assessment, suicidality and other kind of risk assessments, or when it comes to reporting of abuse or neglect, I do document in more detail to make sure that I have the information and to make sure that I have my thinking clearly outlined from that, if you didn't document it, it didn't happen, space for sure.
Okay. I'm going down to the bottom so we can get a mix of questions here. Um, Oh, well, that's another one on notes. Okay. If your clients are involved in a high conflict divorce and have no contact orders between them, you might have to communicate with the parents separately via email or meetings. Is there anything else that you do in these situations?
Um, Typically, I can also, usually if there's a no contact, there is a parent coordinator involved or a guardian ad litem. So I might communicate with them. So getting the release of information to be able to communicate with the parent coordinator or guardian ad litem, and then I only communicate through that person.
Okay. If we find that the client case is too much outside of our scope, them asking for more than we can offer, etc., is it okay to refer out?
Yeah, I think certainly consult with your colleagues and consult with your liability insurance for the best way. But if there's ever a case that ultimately you're not able to offer the best care for them, I think the best thing to do is to refer out.
Okay. All right, let's see. I'm going to just ask one more. What is the best place to go for specific information about your state laws on this?
There's a couple different places. My risk management consultants will answer state specific laws. They give me a person who is familiar with my state specific laws through my liability insurance. Your practice attorney can be one, or potentially your professional organization. The other place would be your like professional code. So you usually take a state jurisprudence exam, and usually there's some informations in your practice act, your state practice act, and then there's going to be state statutes. If you Google like consent or assent for minors mental health, North Carolina, it's going to take you to a statute probably that's going to be relevant for you. And so you can just try your best to type things into Google and it'll usually get you to your state statute that's relevant.
Amazing. Well, we are at the top of the hour. This was incredible. Just as a reminder for everybody here, if we didn't get to your questions, I'm going to send them all to Brittany after we wrap. She will try to answer them and send a note out to you guys with some of those answers. I will also be following up with all of you with a link to this recording along with the slides that we covered today. A giant thanks for going through this. There was so much incredible content. I would encourage anyone who's interested in this to definitely check out the 3-hour workshop because I imagine it's even more granular. Brittany, thank you so much. And I sure hope we can have you again in the future. This was very eye-opening and just so much good stuff to consume. Appreciate it.
Absolutely. I would love it. Thank you to everybody who came, and don't hesitate to reach out if I can be of any help.
Thank you. Thanks to everyone who joined. Bye-bye.